welcome to the City of St. Pete Beach Code Enforcement Special Magistrate hearing for September 11th, 2023. My name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and am board certified in city, county, and local government law. I have been appointed to this position in accordance with the authorities set forth in Chapter 162 Florida Statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today, and I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order in which they appear on the agenda, unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comment related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and, under some circumstances, to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine, and lien may be recorded on your property if the violation is not corrected by the compliance deadline if one is provided. If you wish to present any evidence today, please sign in before you speak at the podium, and it is necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, please stand and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Okay. And before we begin today, if we'd all remain standing, I'd just like to have a moment of silence in honor of the victims of September 11th, 2001. All right, thank you, and you may be seated. All right, do we have any changes to the agenda this morning?
Good morning, Special Magistrate Pete Doerr on behalf of the City of St. Pete Beach Code Enforcement. There are no changes to the agenda. Thank you.
Okay.
I want to take repeat first.
So we'll proceed on to agenda item 4A, new cases. Case number 20230482, City of St. Pete Beach versus Williams Surgical LLC, 3100 Pasagrille Way, St. Pete Beach, Florida, 33706.
So, Madam Magistrator, if we may, because we do have a respondent on the phone, just to get them off, can we take actually 6A first?
Sure. Okay. So let's go ahead and.
Are you there? Yeah.
Okay, so we are going to go ahead and take agenda item 6A, case number 20230468, City of St. Pete Beach versus Mark Carlson, 6440 3rd Palm Point Street in St. Pete Beach. Would the city like to go ahead and, actually prior to proceeding, Mr. Carlson, are you on the phone with us?
I am.
Okay, I am going to trust, were you sworn in when I read the oath, or do you need to be sworn in?
No, I was sworn in.
Okay, so I'm going to trust that everything that you say will be done so under oath, and you have sworn to tell the truth. At this time, would the city like to present its case?
Yes, Special Magistrate. Good morning. I'm Louis Cruz representing the City of St. Pete Beach Code Enforcement. And we have case number 2023-0468, the respondent being Mark Carlson. The violation address is 6440 3rd Palm Point. Violation description: the property was being used as a transient occupancy in the RU1 zoning district in violation of section 8.2A of the Land Development Code of the City of St. Pete Beach. Case summary: the notice of repeat violation was dated 8/10/2023. Notices of hearing dated and posted on the property 8/10/2023. And these are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 6440 3rd Palm Point, August 10th, 2023. And this is the Special Magistrate Order 12/12/2022 by you, Special Magistrate. Respondent number 9 there is respondent is ordered to immediately cease renting the property for a term less than 30 days. And this is the VRBO online ad, Intercoastal Paradise Palm Point. Just wanted to show the property there. And right here, as you can see, he has from Shayla from Plant City. This was July 17, 2022. It looks like they stayed 12 nights in May of 2022, and this was after your order that you had administered to the property owner. This was viewed on August 8th, 2023. And I just would like to show there that the response from the VRB owner was there. Thank you. Thank you for the feedback and glad you enjoyed your stay. This was observed 8/8/2023. And the repeat violation action, the property can only be advertised and rented on a monthly basis. The recommended fine is $500 per night for the 12-night stay in May of 2023 plus administrative costs. And that concludes my presentation. Thank you.
Okay. Mr. Carlson, would you like to make a presentation?
Sure, yes, thank you, Special Magistrate. So, if you were to look at the December 13th order that I received, point number 8 says that within 10 days of the date of this order, respondent shall provide the city proof that there is no future bookings of less than 30 days. So when I was going through the process of correcting all the reservations, I submitted that information to the officer's point. Shayla O'Neill was booked in September 16th of 22. So that was part of the cleanup that I needed to do. When I went through that process, I submitted all the information related to the changes. To my understanding, that was all accepted by Officer Hawk and the staff. My process, and let me give you a little bit of background here. I've been in the hotel industry for the past 30 years, over 30 years. So when I'm handling my home, I handle that is in accordance to what I've done in the past and also how I handle that home currently. So as a reference point, if someone books on an OTA or distribution channel, whether it's VRBO, Expedia, Booking.com, if I'm in a hotel, I don't go back to that third-party platform and make the change to a reservation. I extend the reservation in the property management system itself, which is what I did in this case. Same thing holds true for my home at 6440 Third Palm Point. I've had guests who have enjoyed their stay. They've decided they wanted to extend their stay, and when they ask to extend, I do that in the property management system. I don't do that with Airbnb and VRBO. So I handle that in the same process. As point 8 said, I just needed to make that change. I did make that change in my system. It didn't specify I needed to make it with the OTA or the online tour operator. So when I submitted all my information, I did that. I took snapshots as I was requested through Officer Hawk. He accepted those changes, and I assumed that based on the fact that I went through the process of getting this all handled back in February of 13, that I was compliant based on all the information that I submitted forward. I could have never contemplated that a review on VRBO would show that it had a 12-night stay through that platform. And as a matter of fact, this is the last reservation from the quote-unquote cleanup that took place back from, when this was booked in September of 22 or getting compliance from the last time. So there's no possible way anything could be booked moving forward past that cleanup period, which was back in the beginning of January. And so nothing would have been booked moving forward past January. This is just a legacy reservation that was part of that cleanup process. So I would ask for leniency from the special magistrate and from staff, understanding that the circumstance was that this was all approved and part of the previous cleanup that I needed to do to get compliant.
Okay, Mr. Carlson, I have a question. I think I understand what your testimony is that during your cleanup process, you went through in any reservation that was less than 30 days, you merely extended to a 30-day reservation. Is that correct?
So what I did was I went through and canceled probably about 5 or 6 reservations. And I also went through and I asked some folks if they were willing to stay 30 days. And if they were willing to change the reservation to 30-day reservations, I made those changes. If they didn't want to extend to a 30-day reservation, then that was canceled, and I chose a different one to extend. And so I worked directly with the guests that were on the books at that time, and we called each one of them, and we said, are you willing? And the one that I wanted to extend, we asked first and said, would you be willing to extend to a 30-day reservation? If they said yes, then we extended them in the property management system that we use, not the third-party OTA, because that's a very time-consuming process, and I only had 10 days, quite frankly. I was out of town when I received this. I got it on Christmas Eve, so I was behind the ball and trying to get this done in a 10-day window, and was really focused on just getting the changes done based on the order itself. So every guest that was extended to a 30-day reservation agreed to be extended to a 30-day reservation, and others were canceled. And that was all submitted to Officer Hawk back in the beginning of January 2nd, January 3rd of 23.
Okay, and was Shayla O one of those reservations that was extended to a 30-day reservation?
Correct. So she agreed to extend to a 30-day reservation, and we did that in our property management system. I submitted that to Officer Hawk. He had that documentation. I never did go into VRBO because that wasn't part of the order that I needed to do that, so I did it just in the property management system. And there was another reservation that was canceled in order to allow Shayla to stay the full 30 days.
Does the city have any questions for
Yeah, I
Mr.
do.
Carlson?
Well, I do want to make a point to Madam Magistrate that VRBO has changed its policy to actually designate and list how many nights individuals stay for the comments. So, Mr. Carlson, it's Matthew McConnell, Assistant City Attorney. We've spoken before. I only have one question, and I'd prefer, for the record, for you to answer it yes or no. Did Sheila stay at your property in May for 12 nights?
I don't know whether she did or she didn't.
Okay.
I extended her stay. She was allowed to stay the full time. I did not personally track how long she stayed. I haven't asked the management company. I'm sure they may have more information on that than I do, but I do not know.
So I guess the follow-up question, Madam Magistrate, is do you have any evidence to counter the VRBO comment that says she stayed 12 nights? That was directed to you, Mr. Carlson.
I'm sorry?
Do you have any evidence to counter the VRBO comment that designates that she stayed 12 nights at your property in May?
Yeah, it would be the information that I emailed over to you and Officer Hawk that showed the reservation that was started on June 1st, and I think went to, hold on one moment, let me just pull that up here. Yeah, it went from June 1st to July 1st of 23. So that was the modification, and I took snapshots of that. I did email that over to you at the end of last week. I'm sorry. My apologies. I didn't realize that I needed to submit this information in a certain time period. I knew I spoke with Officer Cruz about dialing into this probably 3 weeks ago. Didn't realize that part of that process was I needed to submit documentation more than 10 days in advance, and I doubled back last week with Officer Cruz just to make sure that I was set and good to go. I didn't know that there was a process for me to get that in 10 days prior. When I spoke with Officer Cruz, that information wasn't relayed to me, so I don't have the documentation that I can submit, although it is in my file from my last hearing, and it is something that I know I sent over to Officer Cruz, and I've sent it over to Mr. O'Connell as well, so I believe the information is in your hands somewhere, and I can resubmit that if necessary, but the screenshot that I did send over does portray a 30-day reservation.
Okay. I have no further questions, but I would like to make an argument before
Sure.
make a ruling.
Mr. Carlson, I do have one additional follow-up question to that. You said that the reservation for Shayla O was extended and it was in June, but VRBO has her stay 12 nights in May. Did she change her reservation, or did she stay 30 days from her 12 nights in May? Can you explain that difference to me?
I cannot. I don't know. VRBO is just a distribution channel to me. It's just a way that a pipe that's a reservation to a PMS system. And my Bible is the PMS system, the property management system. So I can't speak to how VRBO's technology works and why they would consider that. The only thing I can think of is that her check-in date was June 1. So it was, I guess, right at the beginning of or end of May.
Okay. Anything further from you, Mr. Carlson?
No.
Okay.
Okay.
Would the city like to make its argument?
I would like to just make one argument, and Mr. Carlson can, I guess, speak on this, because what I believe he's saying is he extended the block of time 30 days with the understanding that he couldn't rent it for an additional, within that time frame. But our code doesn't differentiate between whether it's blocked off or not. The reality is we have proof in the record that someone stayed there for less than 30 days. So whether you have one rental a month for 3 days or not, it's the city's position that violates our short-term rental ordinance because it is in fact less than 30 days.
And I do have a question. Is the city in possession of the documents that Mr. Carlson submitted with regard to the proof of cancellation or bookings for 30 days only?
We have them, but I'd have to go and get them.
Yeah.
That's fine. I mean, it's you guys have them. It's your case to put on. It's Mr. Carlson's case to put on.
Yes.
So I just wanted to make sure you guys had that documentation, excuse me. Okay, anything further from the city? Mr. Carlson, anything further on your behalf?
Yeah, I guess what I would say is that, when we went through the cleanup process, we called each of these guests. We told them that were they willing to stay the 30 days? And of course they were going to do that at the same price, but they had 30 days as an option to stay there, and they agreed to stay the 30 days. So from my perspective, that is compliant because the guest acknowledged that they had 30 days to stay there and they were willing to do that. If a guest came to me through that cleanup process and that they were not willing to stay 30 days, we canceled that reservation and opted to go with a different reservation through that cleanup process. So that was the crux behind every reservation, is knowing and acknowledging that they had a reservation for 30 days and would stay the 30 days, whether they did or not. Again, that was their prerogative. I know for a fact some of those folks stayed for much longer, or stayed for the 30 days. I don't know whether she did or not specifically, but I felt like I did what I needed to do to be compliant.
Okay.
And I also talked to Officer Hawk about my process and explained to him specifically what I was doing to get myself compliant.
Just
Okay.
one more point.
Yeah, briefly.
So just to counter that, because while I can appreciate what Mr. Carlson is saying, he's now said it twice on the record that he cannot confirm whether this person stayed longer than 12 nights. And the only evidence in the record is that she stayed for 12 nights. So I just like to leave it at that.
Okay. I am going to find that there is a repeat violation, and I am doing so because I only have the evidence that's in front of me, which is the VRBO review, which says they stayed 12 nights, and then Mr. Carlson's testimony. I find both to be credible. The point that I'd like to drive home is, while I agree with Mr. Carlson that VRBO is a third-party reservation system. Ultimately, as a property owner, and I've said this before and I'll continue to say it, you are responsible for what you advertise and for what gets put out on the internet on your behalf. If you are engaging with these companies, ultimately you are responsible for maintaining and checking on those advertisements, checking on those reviews, make sure the information is correct. So due to that fact, I am going to find that there is a repeat violation. However, I am only going to assess the $500 a day fine for 6 nights instead of 12 and associate the reasonable administrative costs. And you will get an order to that effect. Okay. Thank you, Mr. Carlson. I appreciate your time. All right, now moving on to case number, agenda item 4A, case number 20230482, City of St. Pete Beach versus Williams Surgical LLC, 3100 Pasadena Way. Would the city like to make its case?
Yes, good morning, Special Magistrate Steve Rivera on behalf of the City of St. Pete Beach. Case number 20230482, respondents Williams Surgical LLC. Violation address is 3100 Pasadena Way. Violation description: the property was being used as transient occupancy in the Pasadena Overlay Zoning District beyond the 3 times allowed per 12-month period, in violation of Section 20.03B of the Land Development Code of the City of St. Pete Beach. Notice of violation dated 8/17/2023. Notice of hearing dated and posted on the property 8/22 of 2023. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. This is pictures from the VRBO online ad. This was 8/16 of 2023. It's a Google Maps image of the property. This is showing that it's still, you can still rent it less than 30 days. This was on this was posted August 31st of 2023. Shows a 5-night stay in April of 2023. 7-day stay in July, 5-night stay in May, and 4 nights in May as well. Corrective action: the property can be rented for transient occupancy only 3 times in a 12-month period. All of the rentals must be monthly until July 2024. Property is, this should say not compliant because you can still rent it for less than 30 days. It's showing on VRBO that you can book it for less than 30 days. Recommended fines, $250 per day for the 7-night stay in July, plus administrative costs. That concludes my presentation.
Before we conclude, I'd like to ask the code enforcement officer a question. How do you know that on VRBO you can rent it for less than 30 days?
So we went back and actually put in the dates and hit book, and it was allowing the short-term rental side of it.
So for example, if it's limited to 30 days, does it allow you to book?
It would block you out. It usually get like a notice where it would say cannot book for less than 30 days, or to say 30-night minimum.
Okay.
It's not saying that as you put in 3 days, it's allowing you to go through with the booking.
So your testimony is that VRBO has a restriction once the property owner limits it to 30 days that will not allow you to book within that 30 days.
That is correct.
Thank you.
I also have, I'd like to admit to evidence, I'm sorry, before I walk out. We did send a courtesy notice out in April of 2022 to all the residents of Pasadena, reminding them of the short-term rental and then the 12-month stay after that, the 3 times per year, and then the 30 nights after that for the remainder of the 12-month period. Oh, I'm sorry. And I got one more. It's just the VRBO, the agreement for the rental agreement.
The review policy.
Review policy, I'm sorry.
No problem.
I'll put this one away. Here we go. Sorry about that.
Okay. Anything further from the city?
That's it.
Okay, is anyone here on behalf of Williams Surgical LLC? Okay, if you could just come in and state your name for the record. Mhm. And I believe both of you have been sworn in prior.
Yes.
Okay.
So I totally agree.
If you could just state your name for the record.
Sarah
as well.
Williams.
Thank
And
you.
this is Larry. And
Your affiliation with Williams Surgical LLC?
Larry's the managing member, and then it's an LLC. So we bought the property just about a year ago, year and maybe a half now. And we have rented in North Carolina for many years, and I'm an attorney, and I frankly was unaware of the code. So I'm very rule governed. I agree. I rented more times than we were supposed to after reading the code. We did change. I've done all the remediation. My VRBO says 30 days minimum. I just pulled it up again. I can show it to you. It's tricky because you have to do it on a calendar every date, and then you push minimum stay. I've changed that to 30 days. I am not going to accept any less than 30 days. I had 2 scheduled for the rest of the year. One was, let me think. I think one was November, one was December. When I got the notice, I called the renters. I said, I just can't do it. I'm very sorry. Have to cancel. So they've canceled. I've got copies of that. I can show it to you on VRBO. So I've put an ad, a little sign on our fence that says monthly rentals. I've added VRBO. I don't think is going to be very effective with monthly. We did get 2 months when we first bought it. But because I think it may not be that effective, I've reached out. I've done it on Florida Rentals, which is a monthly. I'm advertising in the Cape in a newspaper for monthly, and have the sign on the building. So we don't want to violate.
Okay, and can you tell me when you changed your advertising to the 30 days?
Right when it was,
When you got the
I
notification?
got it, I did it immediately. I did it on the calendar, so I'm not sure what they're seeing, but I'd like to know the dates you're seeing, because I just pulled it up, whoever said that, and mine says 30 days, so I don't know. But that's not our intention, I'm not going to do it. I have a question, though, if I can ask it. Maybe you're the best one as the attorney for the city. What is the 12-month period? It seemed like it's not a calendar year, and it said something like rolling. I read that somewhere, I don't know where. So I'd like to know, just because, I would take advantage of the 3 rentals, less than 30 days allowed, but I'm not sure how the 12-month works.
Well, I can appreciate her question. The city's interpretation is it's a 12-month period.
But
So like, for example, and once this case is completed, our recommendation is going to be for fines for the July, and then you will not be able to rent it for less than 30 days until July of next year.
I still don't understand.
And we can talk offline if you need help.
Yeah, I don't
Okay.
get that. So we corrected everything the minute we got the notice, and here we are. We have no intention of violating anybody's rules, and I appreciate the rule because I'm very cautious about who does rent our property, and I don't want Paso Grill to turn into a frenzy. So I appreciate the rule. And so, anyway, that's...
Thank you. May I ask one question, Madam Magistrate?
You may.
So is it your testimony that all of the comments that we provided in the evidence and the nights that they stayed are accurate?
I wasn't listening that closely. I've got my VRBO calendar.
Yeah, when you initially started your presentation, you stated that I did short-term rent it, right? So I guess my question is, you have 1 5-night in April, 1 4-night in May.
Well, hold on, let me pull it up so I can be perfectly accurate. So, in April, I have the 1st to the 4th and the 9th to the 14th.
That you rented,
Yes.
okay?
In May,
Yes.
the 4th to the 8th, or to the 7th, whatever you want to call it, with the checkout. And then the 19th to the 24th, and the 25th to the 30th.
Okay.
And then there was one in July that was the 29th, and checking out the morning of the 5th. And then I also had one in November and one in December, which have been canceled.
Okay.
And I've got the cancellation. I can show you the cancellation.
Thank you for that, and I appreciate your transparency.
Sure. Not designed to, I'm not
So,
going to hide it.
okay, so Madam Magistrate, obviously we have, based on the testimony, there's more than what we provided, but still the city's position in fairness here is 7 nights in July, 29th to the 5th, $250 a day, plus admin costs, and they cannot rent for a period of less than 30 days until July of 2024.
May I say something?
You may.
So the notice that we received said that things needed to be remedied by a certain date. The date we got the mailing was after the date that was supposed to be remedied, August 21st. I don't sit on things, so I immediately started remedying it. So I have done all the corrective actions, and everything now is going forward strictly with the rule.
And,
I have one question for the city.
okay. I will answer the question, but I do want to respond to that.
Yeah, it's for, probably Stephen can answer it for me. When you're going to make your booking to demonstrate that you can book for less than 30 days, how far are you going?
As far as the book, we just did a couple days, put them in, see if it would take it.
What, I mean, how far are you going into the website? So you go, you put your days in, you hit on the calendar, you hit it, and it lets you go to the next screen,
And you pick your dates and it says book,
right?
and then it goes into the next step, it gives you the pricing for the dates.
And then do you go to the next step? Or do you just stop at that screen?
I stopped at that.
Okay.
And then,
Ma'am, I'm sorry, it's just, okay. And then you had one more question, Mr. McCall?
well, I just want to point out that although there was a compliance date based on the advertisement, the city sees these rentals as irreparable and irreversible pursuant to Chapter 162.09, because the reality is, once you rent it, you can't unrent it, so it's not a violation that you can technically cure. So I just want to make that a part of the record.
Understood. Okay, anything else? Okay. I am going to find that the property was in violation. However, I am not going to charge a per diem fine. To Mr. McConnell's point of the irreparable, I find that the testimony is credible, that the advertising was changed, that the future cancellation, the future bookings were canceled. In my order, you will have to provide proof of that to the city within 10 days. However, for the two that were outstanding, in excess of the 3, and to your benefit, as I told the last person, you know, you're a property owner within the city of St. Pete Beach. You should know what the laws are when you purchase a piece of property. To that, I'm going to assess $250 for each of the stays. So that would be $500 total. I am going to assess reasonable costs. And then just letting you know that in the future, if you are found to have the same violation within a 5-year period, it will be considered a repeat violation and can be subject to an up to $500 a day fine.
And, well, just one thing for clarity, because
Sure.
we provided 4 comments, but the respondent admitted to 6. So if the idea is to go per violation for anything excess over the 3, then we would ask that it be for 3, right? Because she confirmed that there was April 1st to the 4th, April 9th to the 14th, that's 2, May 4th to the 8th, that's 3, May 19th to the 24th, that's 4, May 25th to the 30th, that's 5, and then July 29th to 8/5, which is 6. So I would just ask that if you're going to go for based on your reasoning, that it would be.
I mean, that's a fair point. So I will do for 3 bookings because there were 6 based on the testimony.
Thank you.
Okay. And I will get you a written order to that effect.
And can I confirm that you have an email address?
You will be consulting with the city on that, so the order will come from me, and then you would contact the city for any questions. I mean, do you want to confirm I have your email address?
Well, how are you giving me the order?
How I'm going to send it the same way that the notice of violation was sent, via mail. If you want it emailed to you, please provide your email on the sign-in sheet. Just
Okay,
understand
I will.
whatever email you provide will then become a matter of public record.
Oh, yeah. Okay, I'll do that. Will you put yours?
Madam Special Magistrate, before
Yes.
we continue, point of
Sure.
clarity, and just to ensure what your order is going to say, is it going to say 250 times 3 plus the admin cost?
Yes.
Thank you.
Okay, moving right along. Agenda item 4B, case number 20230412, City of St. Pete Beach versus Douglas Martin and Stephanie Martin, 434 41st Avenue. Would the city like to present its case?
Yes, good morning again, Special Magistrate Steve Rivera on behalf of St. Pete Beach. Case number 20230412, respondents Douglas Martin and Stephanie Martin. Violation address is 434 41st Ave. Violation description, the property was being used as transient occupancy in the RU1 zoning district. Violation of Section 8.12A of the Land Development Code of the City of St. Pete Beach. Case summary, notice of violation dated 7/6/2023. Notice of hearing dated and posted to the property 8/22 of 2023. Following is a true, accurate representation of what I witnessed. Affidavit of posting. This is the Airbnb online ad. This was on 7/6. This is showing 6 reviews. Looks like 3 in July, 4 in July, and 2 in June. This was taken 8/9 of 2023. This is more reviews, 1 in June, May, and then May again of this year. Corrective action, the property can only be rented monthly. The property is now compliant. Recommended fine, $250 per stay for 10 stays plus administrative cost. This concludes my presentation.
Okay, is there anyone here on behalf of the property owner? If you please state your name and address for the record, as well as your association with the property owner.
Good morning. My name is Emanuela Mujica. I am the vacation rental co-host, acting as the attorney-in-fact for Douglas Martin and Stephanie Martin. I have here the power of attorney.
May I see that, Madam
Yes.
Magistrate? Thank you.
I am representing the owners because they are currently stationed in California. Douglas Martin is in the military, and he is currently being transferred to Hawaii today. So they are not able to attend this hearing because they are being transferred to a new posting in Hawaii. So it is our understanding that as of July, there was a, I'm sorry.
No worries.
I'm nervous, hold on. Don't worry about it. Okay. So they received a certified letter from the city of St. Pete Beach. They live in California. We received that in the mail. I went to the post office and I was not able to sign for that notice. It was forwarded to their address in California. They received that, and I have the evidence of that. They received that notice of the violation on July 24th of 2023. Right here. Okay. So, as you can see, July 24th of 2023, they received this notice. It was a warning that that all actions had to be corrected by July 11th, and we have evidence to show that there were no rentals that have occurred after July 24th, which is when they received this notice. I took personally corrective action. July 2nd, I canceled any reservations that were after July 24th. So there have not been any reservations August or this month, and like I said, after July 24th. And I have evidence to show that. It is currently posted only as a 39-minute It's labeled very clearly. I'm just not reading it. Okay. So this is August, totally clear calendar. And this is July. Now, oh yes, of course. So to our, in our defense, we are a property management company, co-hosting company, and we operate mostly in Gulfport and St. Pete. This is the owners purchased this property March 29th of 2023, and their realtor, which was with Compass Realty, told them that they could rent their property. As they're a military family, they were planning to relocate here in September, and so they contacted me to help them with the rental. It's a word of mouth thing. I'm neighbors with their family, friends, and so anyway, they contacted me and we started working together, and we had a conversation to say that it was their responsibility to, you know, understand the codes and everything, and that we would proceed that way. And so like I said, we've taken corrective action since July 2nd. We canceled all bookings going forward since they received that notice on July 24th. And we have not only done it on the platform of Airbnb, but we also have an exclusive right to lease the listing, a listing agreement with my husband, who's a licensed realtor, for a 30-night lease up to actually a year. So we've now transitioned to do an annual rental with the property, and I also have that here to show that listing agreement, which was also originally sent to the owners on July 6th of 2023. So this is the original DigiSign. As you can see, it's dated July 6th for that DigiSign, and this is the listing agreement here. One last thing that I do want to bring up is that we are very community-oriented. We live in Gulfport. We speak to all of the neighbors. We've spoken to the neighbors that have filed complaints. and we had a good understanding with them. I spoke actually on the date that the violation notice was posted on the 22nd. Obviously, the hurricane was coming, so it was actually on August 31st. I went over to the property and I spoke with a gentleman across the street named John, and he said that nothing has been bothering him and everything seems fine. We did hear from the owners that the last complaint on record was for August, and that was actually the owners themselves who were visiting the property from August 8th, August 7th, oh no, August 8th, gosh, I took a red eye, August 8th until August 19th, and they had a rental car, which, that was their flight here to Tampa, and their return flight was for the 19th. They had a rental car, and that's what one of the neighbors used as a complaint, saying that there were more renters there after we were supposed to cease rental activity. That was their rental car. I have evidence of that as well. So there have been no further activities after that notice. Oh, and I have to give all of this right. There you go. And that concludes my presentation. Thank you so much for your time.
Any questions from the city?
I do. Ma'am, do you mind pulling up the printout from Airbnb for July that you put up there?
Oh, it's in this, yes.
Maybe this one?
I think
Oh,
so.
with the overhead?
Overhead, please, Ryan.
So as you can see on the right, that's
Yes.
at a minimum night of 30 nights.
Okay, the reason I bring this up, Madam Magistrate, is because obviously the city's position is that this is a zoning district that doesn't allow for short-term rentals at all. There was 10 reviews. We were going $250 per review plus admin costs. However, if the magistrate doesn't, leave that on, please.
I'm sorry.
If the magistrate sees differently, then at a minimum, the reason I'm bringing this up is because you have a 5-day rental past the compliance date, although this is irreparable and irreversible, and at a minimum, the city would request that 5-day rental times $250 be imposed with admin cost.
May I say one thing about that? So, again, the notice was received by the owners on July 24th. And so there was no real way of them knowing what the situation was until that point. Even though it said July 11th that all activities had to cease at that point, they didn't receive that notice until the 24th.
And that was going to be my clarifying question. You had testified that on July 2nd, you canceled all rentals after July 24th?
That's correct. And that was based on a conversation that my husband had with Officer Rivera at the property, at one of my husband's checks of the property, where he said that we needed to correct this. And so we went on that process of correcting those reservations and canceling everything.
Question is, if you made that change on July 2nd, why not cancel all of the July reservations that were not compliant with the 30-day rental? Why only those after July 24th?
It was our understanding that, and again, this is because we didn't have the official notice. We had my husband had a conversation with Officer Rivera, and we knew that, so the owners had a conversation with the neighbor across the street, and he said that he was, okay with renting the property after July. Up until the end of July. And so, I gave the owner that choice. We can cancel everything, after that conversation that my husband had, or we can cancel everything starting in August. So, so that was the conversation that I had with the owner, and I would just like to ask for, your benevolence in this case, especially because ultimately I am the representative of the owner, it is their property, it is their responsibility, and yet, I'm a mom, I run a business, I try to do the best that I can, and this is going to come out of my business ultimately. So I just ask for that kind consideration on your behalf.
Anything else from the city?
I mean, just to clarify, the notice, statute says we have to send it certified. We did, doesn't require that it's received. So while I can appreciate that point, the city followed the due process in the statute. Additionally, your testimony, you're pretty much advising that you got verbal notice on July 2nd and decided to still, the property owner decided to still rent it in July as opposed to cancel it. So if anything, Madam Magistrate, I think my either or scenario is more relevant than ever at this point.
And anything else from either of you?
Matthew just made the point.
Okay.
Pete Dewar, code enforcement manager at the city staff, actually met with either you or the gentleman sitting there prior to sending the ad.
Okay. Okay, based on the testimony presented, I am going to find that there was a violation, and I am going to assess a $250 fine for each of the 10 stays and reasonable costs of the city. And this is why. Your points are well taken. You are the property manager for the property. However, on July 2nd is your testimony. You found out via the notice, either posted or however you found out in talking with the neighbor, that it was being rented for a period that was in violation of the city's code. You guys had conversations with the city. You then talked to your client, who, understanding, is deployed elsewhere. While you may have given them the option of keeping the July rentals or canceling them, ultimately that was their decision, and they made the decision to continue to violate the city's code. Even though they received notice on July 24th, the notice was sent on July 6th. They had a reasonable time under the statute to cure it, and in fact, they had actual notice before they received the certified mailing. If the circumstances were different and the testimony was different, my decision would be different. However, based on the facts that have been presented, there was a knowing violation of the code. To the city's point, these are irreparable. You can't fix them. They've already been done. And maybe had the July stays been canceled by your client at your client's direction, who ultimately has responsibility, as you said, for the property. They made the decision to do that, and now, unfortunately, they have to suffer the consequences of their actions. There's no way for there to be a cure after the fact. So they knowingly continued to violate the city's code. Based on that, that's why I have my ruling, and I will also put a provision in there to provide proof of no stays from here until the remainder of the year, short-term stays. And you guys will, if you all would like to receive a copy of that order in addition to your client, please just make sure we have your email address on the sign-in sheet. Okay. Thank you. And it looks like, do we have anything else that you'd like to discuss prior to adjourning?
Nothing further, but again, point of clarity, you just mentioned till the end of the year for short-term stays?
Usually, because of the fact that they can't have any short-term stays, and the ones that they can't have any usually just ask for the remainder of the year. That should provide sufficient amount of time.
I'm just concerned about this being a zoning district that does not allow it.
That's
Right, that's exactly why I only make it to the end of
Correct.
the year instead of for the remainder of the 1-year period. Yeah.
Thank you.
Otherwise, they'd have to provide them to you indefinitely.
There is nothing else, however, for calendaring purposes. I just want to make it clear that I believe we're only having one special magistrate meeting on October.
In the ninth, yeah, I'm handling both.
You're holding both?
Yeah.
Okay. I just wanted to make you
Yeah, that's fine. And 10 a.m. still a good time for that?
10 a.m., yes.
Okay. Okay, then we are adjourned.
Thank you.